In the spirit of reconciliation, the FCAV acknowledges the traditional custodians of the land on which we gather, the Wurundjeri people of the Kulin Nation, and acknowledge that they never ceded sovereignty. We also acknowledge Aboriginal and Torres Strait Islander peoples' continuous connection to land, water and community, and we pay our respects to them, their cultures and customs, and to elders both past and present. So as Tessa said, we have Chris Craig, who is from Mackillop, and he is the Manager of Systems and Data, Practice Quality and oversees CIMS for the agency. And Leigh is one of our carer advocates with a lot of experience and has definitely supported many, many carers through that CIMS process. So both bring a lot of knowledge. So Chris, would you like to tell us a little bit about yourself and your role, and welcome, and thank you so much for giving up your time to help us with this.
It is never a problem. Hi, everyone. So my name's Chris Craig, so Manager of Systems and Data Reporting. In terms of my background and full disclosure, Deb and I go a fair way back. So Deb and I worked together 26 years ago in foster care at Berry Street, where we worked together for about 7 years. I was a foster care case manager. And Deb was a coordinator, I think, back then of one of the foster care teams back there as well. So we worked together for quite a while.
Yeah.
And so I was with Berry Street for 7 years. And then after Berry Street, I moved to Anglicare, where I managed their adolescent foster care program and another program called Lead Tenant, which is an exiting care program for residential care, young people mainly, before moving to Mackillop over 16 years ago. So I've been with Mackillop for 16 years now. I started out as an area manager overseeing Northwest Metropolitan Region, which had about 80 foster care placements across that region, as well as 8 residential care homes and 3 lead tenant homes, before moving across to do some project work, which has now sort of morphed into my current role, which is really around, the main part of it is around monitoring incident reporting, which is the CIMS process for Victoria, and then also doing the support with our for investigations that might happen through that. And just like Deb, I should also say some experience in foster care from a different background is my in-laws were foster carers for over 30 years. So my wife grew up in a foster care family, and that's actually what got me involved in Berry Street, actually, but got me looking into foster care as a great thing to do.
Well, thank you. That's amazing. I didn't know that part. There you go. So Leigh, would you like to tell us a little bit about yourself?
Okay, thanks, Deb, and good morning, everyone. I started as a practitioner many years ago, actually 40 years ago, or as I like to say to my carers, I've been in this field since Jesus was a baby. I've worked across Queensland, the Northern Territory, and eventually landed in Victoria. So my background is working in child protection, out-of-home care with agencies, and a range of other sorts of positions. I first worked with FCAV, I think, in 2012. Within carer advocacy work. I then took a couple of years break, and I'm one of those people that couldn't stay away. So I returned to FCAV in 2020 in the midst of lockdown, and here I am still continuing as a carer advocate. Some folks here might know me already and probably could tell some interesting tales of how we've worked together at the time, but I'm really looking forward to talking this through with you all today and hopefully giving everyone a better understanding of particularly FCAV's role in supporting you all through a CIMS investigation, if that ever eventuates for you all.
All right, thank you so much, Leigh. Okay, so we recognise that a CIMS investigation can be extremely stressful and isolating for carers and their families. So I thought it'd be great if we actually spell out what it actually is and what an investigation involves, and then ultimately what support is available to carers. So a CIMS, or Client Incident Management System, is where a particular incident will be lodged, and then as required, a decision will be made to investigate. And it's my understanding that in sort of at this stage, the agency will decide whether it's a non-major, which may be a physical or emotional harm, but result in minimal harm. And, you know, the carer, you might just have to sort of put a Band-Aid on the wound, or, you know, it might be minimal first aid. Or even, you know, the agency might think, well, look, I think the carer might benefit from undertaking some further training, and that could be a specific training that they're recommended as part of a carer development plan. So basically at this stage, it doesn't look like there won't be an investigation. Whereas with a major incident, that can be physical, emotional, sexual, or poor quality of care allegations of abuse, which will be investigated, and that is after advising the department, so within 24 hours. And it could also involve the socket team. So the police have to be advised of any allegations of physical or sexual abuse, and they decide whether that is a kind of a criminal matter, and they might investigate, which often does put things, you know, the agency can't actually proceed until that's sorted out. And then there are also things like the reportable conduct scheme and the suitability panel. So we will explain a bit more about those as we go on. But I thought, Chris, it'd be really great. How are carers advised of an allegation or expected to receive, you know, something like they should be getting a letter with allegations in it. So could you tell us a little bit more about that process?
Yeah, sure. Very happy to. And maybe before I even start, I need to
Yep.
recognise I am from Mackillop. So
Yes.
I am from the experience of Mackillop as an agency. So I'm going to give you generalised information. And so the generalised information is really in terms of partly how Mackillop runs things, but also just to give you some understanding of what could possibly happen. Different agencies might have some very different or slightly different ways of doing things, but in general, most of the things would run fairly similar in terms of investigations and CIMS processes. So very happy to have a chat about those. But as Deb said, I can't speak about specifics things, and I would encourage you to go back to your agencies or to FCAV to help support you in any sort of work around investigations if that's the case. So in terms of thinking through, if an incident happens and it meets a threshold of a major impact, so that is something that would possibly be what they would term severe physical, emotional, or psychological harm to a young person, the process in general should be that the program themselves should actually call you as a carer and actually talk that through with you as the initial point of contact. So the expectation would be that the case manager or the coordinator would call the carers and let them know that there has been an incident or an allegation of an incident in relation to a child or young person. And so that really should be the first point. Most agencies, my understanding, would then follow that up with what we would call an initial letter. So an initial letter is really setting out and giving you an understanding of the CIMS process, and explaining to you that there has been an allegation, and these are the processes that are going to be undertaken in that scenario. Mackillop also provide an agency support person in that letter with a contact, and my understanding is other agencies do exactly the same thing. And then following on from that, we also provide other phone numbers and etc. for support for our particular agency. I think we're talking about that in a little while anyway. So you should receive what's called an initial letter of allegation, but just be aware that an initial letter generally doesn't have a lot of information about the allegation itself, and I'll talk about that in a little while as to why that's the case.
So, like as you probably are aware, Chris, we generally advise a carer not to participate until they've actually got the allegations in writing. So when would that normally be given to the carer?
Yeah, great question. So normally the actual allegations, and we call them, Mackillop call them particularised allegations, happen towards the end of the investigation process. So the unfortunate thing is, in most investigations, you'll find that the foster carer is the last spot that the investigation actually comes to. So in terms of an investigation process, the investigator generally goes through and gathers all the information relating to the allegation to then be able to formulate the allegations in what we call that particularised letter of allegations, which really will clearly spell out what the specifics of those allegations are. Now, the reason for that is so that when the investigator comes to you for an interview, that is so that you have the very details as much as possible of what the allegation is actually about, so that you can actually respond in a fair and reasonable way. So I'll explain it in this sense. Our normal letter of allegation, the initial one, will normally just say there's been an allegation in relation to client who has been in your care and it relates to, and it might be poor quality of care, physical abuse, sexual abuse, as an example. There are a couple of other examples which are a bit strange, like emotional, psychological abuse or financial abuse. So they can also be an investigation type. And so that's what the initial letter would actually set out. The letter of allegation is then sent, which would then have something like, on such and such a date, it is alleged that you did do this by this at this particular point of time. So really what the investigator has done in the process of interviewing, reading notes, creating all their other information that they need and looking at evidence, they are then making the allegations very specific so that you can actually say, you know, if the allegation says that on the 27th of June at 11:20 you did this, you can actually say, well, that's impossible because I was on a webinar and Deb and Chris and so you can actually refute that. So that's why the specifics become really important. So most agencies, and I hope it would be the same, would send you an initial letter and then a specific letter of allegations. And we will not interview, and agencies should not interview until you've had that specific allegations letter sent to you and that you've had a reasonable amount of time to think through your response.
That's great. And that, you know, that does make a lot of sense. There's, you know, making sure that you've got all the information you can so that it's as accurate as possible at that time.
Very much so.
Yeah.
And I think the hard thing, so Mackillop, I should say, different agencies use different processes. Mackillop uses an external organisation for our investigations. So we don't have investigators within, I'm a trained investigator, but we don't actually have investigators within our team here in Victoria that do investigations. We go to an external agency to do that, to provide this understanding that they do the investigation, that's there, they run with the investigation, we provide them with information or try and link them in, etc., etc. But we give them the information and those external organisations do the investigation for us. Some agencies have internal investigators that do investigations. So there is some difference, but in general, the process would generally be the same. Yeah. And the investigator will actually interview people who might have made the allegations, people who might have witnessed the allegations, the child or young person. So there's lots and lots of interviews that might be happening while in between getting that initial letter and when you get that actual final letter of allegations. And sometimes that can be a long process. So if police are still investigating, we can't actually do anything. And we need to be able to give everybody the opportunity to have their voice in this investigation process. So sometimes that is things that slow things down for long periods of time. So my encouragement, and Leigh and I have lots of conversations about this, but my encouragement is if this happens and you have the initial letter and you feel like nothing's happening, trust me, there's a lot of stuff happening where organisations and people like me are working very hard to try and get this process moving, but there's lots of things that can actually slow this down.
That's great. And I know, Chris, you said in regards to, you know, how can we support carers through that process, that often there'll be, like for your agency, there'll be an allocated worker they can talk to. Yes. but I'm, and there's also, some organisations have EAP.
Yes.
We also have the Carer Assistance Program. But Leigh, do you want to tell us a little bit more about the support that Foster Carer Association offers to carers through that process?
Okay, thanks, Deb. I'm going to start from go to woe for you all, and I'll hopefully not be too wordy with this. But process usually is a carer will call FCAV, distressed, concerned. We've been advised we have an investigation. In some circumstances, not only has a carer been advised that they have an investigation pending, but also their foster children may have been moved as a result of the allegations being made. And so first phone call, basically the carer advocates will walk you through firstly what is happening, what has happened to date, who's advised you of the allegations, have they let you know what the allegations are yet? When were the children moved? What was the explanation for the children being moved? And I should say, kids aren't always moved, but we operate in a very risk-averse system around potential harm to children. So it's unsurprising if kids are moved at times from their placement with a carer at the start of an investigation. So initial call is that discussion. Firstly, what's happened to date so far? How much information do you have as a carer? And often carers will say, well, we don't have anything yet other than what our case manager or the team leader in the out-of-home care team have told us. Some carers say, we're not being told anything. And often when carers aren't being told anything and they're being told they can't be, when the agency says, we can't say anything to you yet, that would to us indicate that there's been a referral across to the socket team with the police to assess the allegations to see if really that hits, I guess, the benchmark, for want of a better word, for socket to be more involved in some level of investigation, firstly. Once we clarify that, usually as advocates, for example, I will ring Chris if I have a Mackillop carer saying, oh, they've rung me, I have this investigation. I'll call Chris and see if there's any background and what sort of, I guess, timeframes for that initial letter of advice is to go out, what the process will be, possibly even who will be the investigator. Usually I know who the investigator will be from Mackillop. So, but that goes across to all agencies. That's how we practice. If the carer would like us to, and look, we don't contact agencies without a carer's specific consent. I must make that really clear. I don't jump up and go, oh my gosh, I need to ring Ozchild or Key Assets and find out what's going on, unless the carers give me consent. I won't make any inquiries without that. Once we make those contacts, though, and get a bit more of a picture, of course, we stay in contact with a carer, with carers, and often our role is partly information gathering as time progresses. Just getting updates on how the investigation's progressing. Do we have timeframes yet? Looking around when carers will have their own interviews with the investigator. So we'll always check progress for carers. Part of those conversations with carers are, I would define as some counselling, where you safe space to have express a very honest opinion of what's happening for you. We also encourage carers to self-refer to our care assistance program. I often explain this to carers as there are two parts. In my role as a carer advocate, I'm doing the nuts and bolts and the practical casework on their behalf, checking where things are, where the investigation's progressing and so forth. Our colleagues in the care assistance program are much more, well, we call it therapeutic intervention. I often say to carers, to put in very plain language, care assistance program is your safe space to be distressed, be angry, to vent, to express your opinions you can't express to anyone else, and to have an outlet for the emotional impact of an investigation. And I don't think it's unreasonable to expect every carer is going to be very distressed and very angry about having an investigation undertaken around their care of their foster children. That's a bit of a nuts and bolts of the initial work. Once we come through to the point where a carer will, or carers will have their interviews, FCAV's role is, if the carer would like us to, our role is to sit in on the interview as support. Now, it gets interesting because we're titled advocates, but we do not have a role in the actual interview process other than checking that the carers are feeling comfortable. Is not the word. You won't never feel comfortable in the interview, but we also want to ensure that if carers are getting upset, distressed, that they can call for a break. And usually my experience is that the investigators are very tuned into how the carer is feeling during that interview as well. And they will check in with the carer. Would you like a break? Do you need some time out? On some occasions, they've actually said, do you want to talk to Leigh for 5 minutes? We'll call a break. You have a chat to Leigh, and then we'll come back to continuing the interview. The only time I've actually been more of an advocate in an investigation interview was an occasion when the investigator started to introduce new allegations into that interview. That's absolutely not allowed. And I did, in fact, interrupt that interview and say, you can't do this, because carers' rights are that they receive allegations in writing so they can prepare to respond in the interview, not get hit with cold allegations that they're not prepared for and that they can't prepare a response for. And I did interrupt that interview and basically made it clear to the investigator at the time, we can continue the interview in relation to the existing allegations. If you want to pursue this new set of allegations, you're going to have to put those in writing again to the carer, and we'll have a second interview. So that's really the only time I've actually sort of really put a very strong advocate's hat on. That was a very rare occasion, I must say. The investigators, in our broad experience, are very ethical. They're very patient. They will walk through all the allegations with carers, but it's not exactly a Spanish Inquisition either. But, you know, eventually in the course of the interview, carer is going to have to be responding in some detail to what's being alleged so that the investigator can, you know, be fully informed in preparing their investigation report. Having said that, carers do have the right to respond to allegations in writing if they would prefer not to go through an interview. There are advantages to that in terms of not putting yourself through an interview experience if it's really anxiety provoking for a carer. The disadvantage is in putting responses in writing to allegations, you can sometimes lose context, which is much better to explain in the face-to-face interview. So, you know, we advise carers of both those options. They are both carers' rights to take whichever action they're most comfortable with, but there are certainly advantages despite the anxiety and the stress of preparing and undertaking an interview to actually doing an interview. You can talk much more to the allegations and give the investigator a much clearer picture of the placement, of the issues, and what perhaps was the context of events that have suddenly turned into allegations of potential mistreatment of children. I almost forgot to tell you that before the interview, our other role that we undertake is to do a bit of a pre-interview discussion with carers. So if I have a CIMS interview tomorrow to sit in on, I will meet with my carers today and we'll just talk about the allegations a bit. I'm just ensure that they prepare some notes for their responses, just prompt notes, because when it's like a job interview, you walk in, you do the interview, you walk out and you think, oh my gosh, I should have told them this and this and this. So a little bit of preparation happens in that discussion with carers. Also discussion exactly of what FCAV's role will be in that interview. So carers don't think we're going to come in and act like their solicitor, their barrister or whatever, but exactly how we actually sit through the interview. And also we talk about questions that the carer may have for the investigator at the end of the interview as well. So that's a bit of a Reader's Digest version. It goes on a lot longer over quite a period of time, but that should give you a bit of a picture today of how we work.
And the other thing at the end, I guess, too, Leigh, is that we can be there to provide sort of debriefing after the interview as well. So
thanks,
that's
Deb.
the other side of it.
Yes, we do debrief you. Often I will ring carers as immediately after their interview's concluded. I usually say, look, some carers will say we're going to go and have coffee or whatever. I say, fine, let's set a time. I want to talk to you this afternoon, just see how you're doing. So that's a little bit more of a pastoral role, I guess, for want of a better word. It's not quite counselling, but it's just looking out for my carers when they've been through what is a pretty tough hour or two of talking in an interview with an investigator. Thanks, Deb. That's probably one of the most important things we do.
Yeah. Oh, look, I think, the whole process of, being prepared and making sure that you're aware of what might some of the questions be, if that makes sense. But so definitely doing that preparation for the interview is really vital as well. So that's good. Well, thank you. So Chris, in general, who is responsible for conducting the investigation? And I know this will be really hard, and you've already said that, it's often very difficult to give timelines, but in general, how long does it take?
Sure. So as I mentioned earlier, I'll actually explain, it's up to the agency to arrange for the investigation to occur. So it's up to the agency to do that. And different agencies have different expectations. We, as I mentioned, use an external investigator. Some agencies use internal investigators. Some agencies I'm aware of, some smaller agencies actually cross-reference with bigger agencies and use their investigators for their investigations as well. So, but an investigator needs to have a specific qualification or hire to meet that requirement. So there's a specific requirement. So the people that are used are generally ex-police detectives is who you'll find, or people who have a private investigations background. So most of them have really high experience in terms of running investigations. So and doing that sort of process. So the agency is responsible for conducting it, but they do it in different ways with whoever they do use as an investigator. And in terms of timeframes, as Deb mentioned, as I might have alluded to, timeframes are difficult. The process of CIMS, so the actual CIMS guide actually says that organisations have 28 business days to complete an investigation. Now that 28 business days only starts when the police have actually agreed, if it's something that involves the police, for example, that only starts when the police have actually given written permission generally to an organisation to say that we can commence an investigation. So that can be something that extends out that investigation timeframe. Other things that can extend out an investigation timeframe past that 28 days is having access to children or young people that we might need to interview, or allowing carers enough time to be able to prepare, say with Leigh or someone from the or Bibba from the FCAV around the investigation. So there's lots of things that can slow the process down. One of the things that we are very big on, and I would suggest all organisations are, is actually capturing the voice of the client, capturing the voice of the people who might have brought forward allegations, and capturing the voice of carers and other people in this process, so that the process is a fair and unbiased process as much as we possibly can. And so we might need to, for example, offer a young person who initially declines interview, we might need to offer them 2, 3, sometimes 4 opportunities to be able to put forward their viewpoint prior to be able to move on and say that they're declining an interview, for example. And so that can stretch out over a week, 2 weeks. And so that can then make these timeframes stretch out. In general, my expectation would be it is showing to be about somewhere between 3 to 5 months is generally how long some of these are taking, is probably the experience. And some of that is also other processes that slow it down at the end process as well, once we've done our bit. But I think we're about to talk about that.
Having, sort of, and that's probably around the general time frame that most that I've experienced. They're at least 3 to 5 months. Sometimes they do take longer, unfortunately. But once you have completed the investigation interviews, does DFFH need to review and meet regarding the outcome of the investigation, or are there other processes that need to be done?
Yeah, great question. So when an agency completes an investigation, the investigation gets sent to a part of the Department of Families and Fairness and Housing called Safeguarding and Oversight. So they are a separate part of the department. They don't report in through child protection. They are not linked with child protection. They're a separate part of the department, and their role is to undertake the monitoring of CIMS and CIMS incident reporting, and also investigations. And they are then required to read the investigation and make sure that all of the elements of what's required for a good investigation are covered, that the reasonable information and evidence that has been provided by the investigator meets the threshold of what the actual allegation is about, that there's a clear analysis of the findings that the investigator has come to, and also that there is a clear undertaking of a response plan or an action plan that the agency needs to do because of this investigation. And so sometimes they're the other process that can slow things down, because we might provide an investigation to the department, who then might withdraw it back to us saying, has this been considered? Has this been considered? So they're looking at it from a child safeguarding perspective with a real emphasis on child safeguarding, and then we would then go back to our investigator and we might be able to answer those questions quickly and then send the investigation back. I will be fair to the safeguarding and oversight team of the department. Just in terms of size, there are 2 teams that cover all of the incident reporting and investigations that go through all of Victoria for all DFFH funded services. The teams have 4 people in each of them and a manager oversighting all of those. If you consider Mackillop puts through about 350 to 400 incident reports a month through to this team, they're reviewing all of those within this team of 5. Other organisations have similar amounts. So the department are probably getting about 8,000 to 10,000 incidents a month. Wow. And the team of 10 people have to actually monitor those and then read it. So once we get them to the department, it's generally taking about 2 to 3 weeks for them at the moment to be able to get an investigation read and endorsed and then back to us as an endorsed, or they might withdraw it and then we'll have to send it back through. But once it's withdrawn the first time, it generally doesn't take too long for them to actually check that we've covered off the areas that they've requested. So even though we've sent it, sometimes it can take 2-3 weeks for them to come back, is generally about the time frame I think we're finding, isn't it, Leigh? Because I talk to Leigh about this a lot. Because Leigh says, "Where's this at, Chris?" And I have that conversation.
Chris is regularly humbugged by me about what's happening with my carers reports. Have you got outcomes yet? I think the time frame also depends on the complexity of the investigation, and of course, complexity of investigation is affected by the nature of the allegations. We sometimes get very straightforward allegations that can be sorted, for want of a better word, assessed a little more quickly than others that are complex. They may relate to a number of children in a placement. They may be historical allegations, and that can make the progress and process somewhat longer, because you're obviously an investigator's having to go back and find people and so forth. So really, I mean, I do have some cases that have waited beyond those timeframes Chris mentioned, not necessarily Mackillop cases at all, but across Victoria, we do find time lags, but there are often, there's a pretty clear context why it's taking so long. They are very complex, complicated matters that the department may well look at the initial report that's sent up to them and go, we've got more questions around this case and this investigation, and it has to come back to the agency and hence back to the investigator for some more follow-up. So yeah, we'd like to think that the time frame is timely. However, there are certainly circumstances that we're aware of at FCAV that the timeliness is probably, while it's of the essence, it's not what we're hoping for. We just continue to support our carers through all of this as much as we can until we get to the end of the process with an outcome.
Thank you. Chris, I also understand that from any investigation, the agency also looks at whether there are any gaps in their service and then aim to address these for future practice.
That's very true. So, and that's part of what the investigation outcome plan really needs to be about. So sometimes what we might find is that there might be an issue that the agency says, actually, we could stop this sort of incident happening in the future by putting in place this practice or undertaking this procedure or looking at that. And we would then implement that, and then we actually get monitored on our implementation of that by the safeguarding and oversight team as well to make sure that that's happening. So there are occasions that actually does occur where the investigator comes to us and says, look, there's a problem here and you guys need to do something about it, and we would then implement that as part of our action plan that actually goes into the investigation outcome as well.
And I know, Sorry,
I was just going to add a little bit to that when Beba or myself or even yourself do that pre-interview discussion preparation with our carers, I always remind carers that part of their conversation with the investigator in their interview is to actually talk about what was happening around the placement in terms of support from the out-of-home care agency team. So it's a case of, were you requesting respite? Was that being addressed? Were you receiving appropriate respite? Were the kids able to arrangements made for the kids to attend therapy appropriately? We asked them to talk about that. Do you get regular care team meetings? Did you have regular home visits? So when a carer does their interview, they don't just respond to the allegations, but they talk about what was happening around the placement in terms of, was the agency fulfilling their responsibilities to you as a carer in ensuring there was appropriate, adequate support in place to maintain your placement? So sorry, I just wanted to add that bit because
that
Chris
was
prompted
good
me with that.
And maybe I should add. Sorry, Deb, go ahead.
I was just going to say that I often do hear from carers that, you know, there's often that lack of support from the agency, which didn't help the situation in regards to whatever the allegations were. Sorry, Chris, what was that?
No, I was going to say, so some agencies, just to give some generalised information, some agencies might not put that in an action plan, but they might actually throw that through a complaints process, so their internal complaints process, and they might not put it into an action plan. Some agencies might put it into an action plan. So it's just, it sort of, please feel free in that, as Leigh said, think about the context of what was happening around that time and what might not have helped or supported in that instance, and then agencies will then make a response. But if it's not in an investigation plan, then it could go through a complaints process or an improvements process as well. So some agencies might do it slightly differently in that sense, but still please feel free to think through those things and have an indication of that.
That's good. And then ultimately, if a carer is not happy with the outcome of the allegations, what could they do in regards to, you know, is it a complaint or, you know, can they?
Yeah, great question.
Ask for a review.
In terms of ending an investigation from our point of view, what happens is the safeguarding and oversight team would send us what's called an endorsed investigation report. Our requirement, so this is a Mackillop process, so I'm being careful, but a Mackillop process would be that we would then, through the program, send a letter of outcomes. Now, agencies are required to send that out anyway as part of the CIMS process, but in terms of different agencies might do it differently. Our expectation is that our program staff would call the carer directly and say, we have the letter, let me talk you through it, because the letter might be not substantiated, okay? And I would suggest that quite regularly there's not substantiated allegations. And so the letter would then actually state that, but our expectation is that the carer is actually phoned by the program, because we want you to have that relationship with the program. If for whatever reason an investigation comes back as endorsed and it's a substantiated allegation, you have every right to request a review. Your letter should actually state, your outcomes letter, if it is a substantiated allegation, should state that you can actually request that review, and you have 14 business days to request a review back to the agency. So it's not 14 days, it's 14 business days, so it works out to be nearly 3 weeks that you have. Now, some agencies put that very specifically because they actually say, can you give us what you want, what you think is not there. Mackillop thinks about it in terms of a bias process, or whether we didn't meet the principles of a fair and just process. But you can actually request a review just by writing in an email to your organisation to say, I would like this review request, this outcome reviewed. And then the organisation is then required to implement a review. And a review process, just as a really quick thing, the organisation is then required to implement what's called a lead decision reviewer. The lead decision reviewer has to be different to the initial investigator. They have to have no sort of bias or anything, or any sort of previous understanding of the case itself. And the lead decision reviewer's first point of call is to actually ask you as the carer what you are actually requesting a review. What are your reasons for your review? And so you then get the opportunity to provide that information, and then the lead decision reviewer reviews all of the documentation and all of the information that the investigator has gathered, including evidence, and then they make a determination about whether that should be overturned, or that outcome should be overturned or not. So it's really up to the lead decision reviewer to do that. And at the end of that process, in terms of the CIMS process, there's no further process that you can go on. So if a lead decision reviewer makes the determination that it is still a substantiated outcome, the CIMS guide doesn't provide a further outcome from that. So that's the end of the CIMS process in terms of an investigation.
Thank you. That's good. Leigh, there are also some dual processes within the system, such as like the suitability panel and CCYP, so the commission. I understand that the suitability panel operates as an independent body and assesses whether an allegation of physical or sexual abuse against a child is proven and whether, as a result, a volunteer or even a worker is found to pose unacceptable risk of harm to children and is therefore disqualified from being registered to, to work within the system or to provide care. So when would they be involved in the allegations and that process?
Yeah, thanks, Deb. Look, it's a little bit of the system can look a little bit confusing at times. So where allegations are made, there is the CIMS investigation. That also runs concurrent with the referral to what's called the reportable conduct scheme, who sit within the Office of the Children's Commission. So reportable conduct scheme, and Chris, please come in on this. I always am happy for this explanation to be fine-tuned. But reportable conduct scheme really looks around slightly different levels of or benchmarks of allegations. There's a
Yes.
slightly different level there for
They
them
are.
compared to a SIMS. So, Chris, do you want to just run
Sure.
with that little bit, and I'll go back to
Yeah. So the
suitability
reportable
panel.
conduct scheme has similar allegation types as to CIMS. I think the big difference and the big determination, or the big thought that's the difference between CIMS and reportable conduct, is that reportable conduct also has this threshold of an understanding that an organisation has to have a reasonable belief that the incident has occurred. And so what you might find is that there might be an allegation in CIMS that goes to an investigation process, but the organisation says, actually, all we have is someone's word to say that they believe this allegation has occurred, and we don't have other things to actually indicate, or don't have a reasonable belief that this might have occurred at this point of time. And so sometimes what happens is an investigator might be doing an investigation into a CIMS, and they might get 3/4 of the way through, and they might call the organisation and say, hi, I'm just letting you know I've now got enough information to actually form an understanding that things aren't looking good, and then we might then make a reportable conduct scheme allegation on the basis of that. Now, the thing with Commission for Children and Young People that's very different to CIMS, CIMS can only come through organisations. Reportable conduct schemes, anybody in the state of Victoria can actually call and make an allegation against anybody in terms of their care within an organisation or anything like that. And they can just say, I've formed a reasonable belief that this has happened to this child or young person. And we would then be required to investigate it because someone has formed a reasonable belief. So sometimes you might get cases where a parent of a child might make an allegation directly to the CCYP and say, I've formed a reasonable belief that this is happening in this foster carer's household. And the organisation that is supporting that carer would then be required, whether they agree with it or not, they would still be required to do an investigation on that. So there's some different thresholds. And the other one that I might talk about a little bit later is there's different thresholds of how the investigation outcomes are looked at. So a reportable conduct scheme and a CIMS investigation is on a balance of probabilities. So they call that the Briginshaw standard. But a Section 8182, which is the suitability panel investigation, is actually on a criminal standard that they need to look at. So I won't bore you to tears with too much about that, but if you want to ask some questions about that at the end, you can.
Okay, and that's a nice segue into the whole Section 81 scenario that some carers find themselves confronted with in addition to their CIMS. So basically we explain it to carers as where there appears to be significant physical or sexual abuse in most cases being alleged and being investigated by CIMS. a Section 81 referral can be made to the department's Human Service Regulator. There's lots of titles in here that sound slightly Orwellian, and I'm sorry the department don't just say a very simple title, but that's where it goes. So the allegations are sent on to that particular unit in the department. They will advise a carer in writing that a referral has been received, and a decision will be made at some point in due course as to whether a second investigation will be instigated. So you may have come through your CIMS investigation and think, great, that's over, thank goodness. However, you may then be coming into the second step, which is Section 81 independent investigation. Now, in my experience, the majority of those Section 81 investigations occur when allegations are substantiated. However, I have in fact had a couple of cases where the CIMS investigation was not substantiated, but the Human Service Regulator team decided there should be a second investigation because of the nature of the allegations. I think both cases were around, alleged sexual abuse, grooming, etc. This takes quite some time. I've had carers who haven't got to their independent investigation interviews until, nearly 2 years after their CIMS was completed. They're down the track and suddenly they're in a whole new investigation scenario. Where that independent investigation substantiates allegations, there is a referral put up to the suitability panel. Now, suitability panel is, I think it's fair to say, a pretty serious matter to take on. It is literally a panel of professionals, lawyers. I think there are psychologists and so forth, but people with very, very deep experience around these issues around abuse and the legal system. If the suitability panel decides to hold a hearing on receiving the independent report, the Section 81 report, there's a whole new process. Again, carer is notified that they are going to be subject to the hearing. Carers have the option to not attend the hearing, to not participate in the proceedings. However, again, we do point out to carers that, yes, that's your right, but it can put you at a pretty major disadvantage again, because you're not able to be putting through your own case around why the allegations are in fact not true. Now, I've had carers who have actually engaged lawyers for these hearings, and I think that's becoming a little more common where carers can afford to do that. It's a very expensive undertaking to have. Some of them actually get barristers. One of my carers got a King's Counsel, and I would hate to think how much money that carer had to spend on legal fees. But that person's view was, I need to clear my name because these allegations are totally false, and the implications for my future, my Working with Children check, are just too serious to just go in and try and defend myself in this situation. Where carers go in without legal representation, the panel will do a lot of the cross-examination of witnesses, because witnesses are called. This is literally a hearing. It's not just a read through a report and ask the questions. It's a hearing. And so the panel is cognizant that not all carers can afford exorbitant legal fees to defend themselves. So they will do a lot of cross-examination of the witnesses. Where carers engage a barrister or a solicitor to represent them in these proceedings, the department will usually send along their own legal representation as well to be cross-examining witnesses also. And as Deb said, the implications of the allegations being found to be proven, firstly, will be that the panel will contact the Victorian Carer Register to advise that allegations are proven, therefore the carer should be removed from the Victorian Carer Register. You just don't get to ever be a foster carer again in those circumstances, because obviously the Victorian Carer Register is going to have reasons for deregistration attached to your name on there. So it's not an incredibly frequent event that carers get referred to suitability panel, but we certainly have quite a bit of experience of when they are. And time frame wise, that actually is not a quick process. It can take 2 to 3 years, and particularly since all the lockdowns, there has been an enormous backlog of cases that have caused such delay. The main point for carers to know is that we continue to support them through these processes. I have carers, and they've had, as I said, they've had their CIMS 2 years ago. They've gone to a Section 81 investigation. They just come back. We keep the support rolling as they need. We never say, oh, well, you're on your own now, go and get a lawyer. We're always there. And where carers would like us to, we'll also attend the suitability panel hearing as support also. And the hearings aren't necessarily over in a day. I've had one that took 5 days previously. So it can be a very long process to get through that experience as well. That's pretty much, I think, the end of the road. Once you get to suitability panel outcomes, then really I don't think there's not anywhere else to move. I think that's pretty much it. One element I haven't mentioned today, which many carers worry about, of course, is working with children checks. And that's such a question all the time. Where allegations are substantiated, I think around not so much emotional abuse, it depends on the severity of the substantiated allegations, but a referral is, of course, sent to the Department of Justice, who manages working with children checks. Carers will then receive a letter from Working with Children Check, the Working with Children Check team, advising their Working with Children Check is now under review, and it will be suspended for the time of the review in most cases. And that correspondence will also, it's about a 5-page document, depending on how many allegations have been substantiated. But the carer is required to respond to a whole range of questions around the allegations, around their thoughts about the substantiation, what action they have taken to address issues, why they don't present a risk to children any further, all sorts of things. I won't go through. You can have so many questions. I won't go through all of them, but that's a bit of an example of what these letters look like. We also ensure that we can support carers in preparing their responses. I often say to carers, draft up your responses. I'll have a look, because there may be aspects of the carers' conversations and disclosures around agency support, or what's put in place as a carer development plan post the CIMS investigation, that we can also add to. We don't actually advocate for carers to keep their Working with Children checks, but we will always help work through really good, solid, honest responses back to Department of Justice. So carers can inform the Department of Justice really fully about why they should keep their Working with Children check. Some carers will say, well, I'm not going to be a carer anymore. I've made that decision. I've asked my agency to no longer maintain my accreditation. However, I need my Working with Children check to coach my grandson's soccer team twice a week. I don't present a risk in that scenario at all. So we make sure, carers, what's the purpose of keeping the Working with Children check? For some carers, it is to keep on caring, but for other carers, it's also employment. It's community activities, like I said, the soccer team. I had some carers who didn't want anything to do with their investigation. they decided they didn't want to be carers anymore. When I raised the issue of the working with children check, they just went, well, we don't need that either. We're retired. It's not like we're going down and playing Santa at the local town hall Christmas party for the kids, and we're not volunteers for anything to do with children, so we don't care anymore. They just drew a very clear line in the sand, and we had to respect that. I just made sure I spoke to them about pros and cons, let them make their decision. We never tell you what to do. We give you pros and cons around all these situations with investigations and consequences of investigations. Carers then can make, I hope, a well-informed decision about which pathway they want to take with each of those scenarios.
And maybe just as a clarification, the CIMS process doesn't impact a working with children check, but the reportable conduct scheme process does.
Yeah.
So there's those two sort of separate processes that might have different implications.
Thanks, Chris.
Great, thank you. Thank you both. The other thing I thought I'd look at just quickly is, what other resources are out there, and the things that I've come across are the DFFH guide for out-of-home carers in regards to CIMS. Definitely FCAV has a carer investigation fact sheet and a brochure on CIMS that we can send out to anyone. On top of that, we have obviously the carer advocates for support during the process, and then also the carer assistance program, so that provides that free counselling for foster and permanent carers. And, because we know that, going through CIMS can often trigger that grief and loss, and particularly if the kids have been removed, that's even harder for everyone. So there are a few of the things that are out there available, and I can, if anyone wants a copy, just let me know and I can send them out. And I can also send you the link to the CAP service if that would be helpful. So we're going to stop the recording now.